Hello and welcome. We are back with more Supreme Court justices of the United States Supreme Court, the judicial branch. Before we jump into the video, I do want to go ahead and remind you I've got two ways to donate to the channel. I have a Patreon account, which is a monthly, month-to-month donation system. And I also have a Coffee account, which can do much the same, but it also allows you to make single one-time donations. I'll have links to both in the description box below the video. We'll turn you down just a bit. I don't know why it's spiking out like that. How about if I do that? Well, it still spikes out quite a bit. We'll do it on this end. Hopefully that'll cut it down a bit. Anyway, do not donate if you are in financial trouble, or donating will put you into financial trouble. Take care of what you need to take care of first, please. It's tough enough with all the idiots in charge right now. If you can afford to donate and you wish to donate, thank you. I do appreciate it. It's me, myself, and I. I do the research, the filming, the editing, the posting, all that. And I don't do commercials as a personal choice, and I'm not getting paid for any of the videos as of yet. So, yeah. With that said, let's go ahead and hop into the video. Today we are looking at Joseph McKenna and Oliver Wendell Holmes Jr. First, let's look at McKenna here. He was preceded by Field, who was Field. Ooh, so we going back a ways. Stephen Johnson Field. That's who McKenna would replace on the court. McKenna himself would be confirmed January 21st, 1898, through acclamation in the Senate. Being on the court from January 26, 1898 to January 5th, 1925, retiring after 26 years and 345 days, so almost 27 full years. He's the only justice appointed by William McKinley because, of course, McKinley himself would be shot in office. And then the other one we're going to take a look at is Oliver Wendell Holmes, who replaced Gray. Horace Gray. Oliver Wendell Holmes Jr. Would be confirmed December 4th, 1902, being on the court from December 8th, 1902 to January the 12th, 1932, retiring after spending 29 years and 35 days. And he was the first nomination for the court under Teddy Roosevelt. McKenna was from California and Wendell Holmes Jr. from Massachusetts. First, let's take a look at McKenna from Justia. McKenna um, joined the U.S. Supreme Court January 26, 1898, replacing Stephen Johnson Field. Was born August 10th, 1843, in Philadelphia, Pennsylvania, but his family moved to California in the 1850s. There, he graduated from the law department of Benicia Collegiate Institute in 1865 and was admitted to the California bar in the same year, spending a short period of time as district attorney of Solano County soon afterward. He served one term in the California state legislature in the 1870s. He would twice fail to win a seat in the U.S. House of Representatives, but on the third time he got in, and he finally reached the House in 1885 and would be selected to 3 more terms, so spending 4 in all. He resigned from the House in early 1892 after he was appointed to the U.S. Court of Appeals for the Ninth Circuit in 1897, joining the administration of President William McKinley as the U.S. Attorney General. McKenna spent just 9 months as Attorney General before McKinley nominated him to the Supreme Court on December the 16th, 1897. The Senate would confirm him on January 21st, 1898, and he would take the judicial oath 5 days later. He wrote a pair of opinions upholding the Pure Food and Drug Act and an anti-sex trafficking law called the Mann Act. He also upheld a state law limiting the workday to 10 hours and voiced a progressive view of the Eighth Amendment prohibition against cruel and unusual punishment. However, he wrote for the court in rejecting a challenge to the 1890 Mississippi Constitution, which sought to disenfranchise African Americans. He would suffer a stroke in 1915, which diminished his capacity in the last decade on the court, and Chief Justice William Howard Taft finally persuaded him to resign. He would leave the court on January the 5th, 1925, and die November the 21st, 1926, in Washington, D.C., being replaced by Harlan Fiske Stone on the court. Most notable opinion was Weems versus the U.S. in 1910, dealing with death penalty and criminal sentencing, and what it basically did was it said the Eighth Amendment is progressive and may acquire wider meaning as public opinion becomes enlightened by humane justice. So yeah, just depending on how the court, the people may look at it, may see the amendment itself. Let's go ahead and jump to Oye and look at it here. He was the son of Irish immigrants and attended public school and studied law at Benicia College Institute, and graduating in 1865, entering the practice of law a year later. But politics had more allure than the law, and McKenna pursued Republican issues in his community. Remember, this is still the age of the Republicans, who were actually the party of Lincoln Republicans, not Republicans as we know them now. McKenna served 4 terms in the House of Representatives, then would be a circuit judge, and then briefly serve as Attorney General, and his loyalty was surely the basis for his nomination to the High Court, for experience would confirm that it was not his ability that merited his elevation to the nation's highest tribunal. In fact, two federal trial judges took the unusual step of publicly expressing their view that McKenna was unfit for the office based on his performance as an appellate judge. He may have acknowledged his lack of preparation when, after his confirmation, he studied law at Columbia Law School to prepare for the burdens he would face as a justice. There is doubt that the last-minute tutoring had any measurable improvement on his ability as a justice. Irish, Roman Catholic. Family was of lower middle-class status. Mother May Ann Johnson and father John McKenna. Father was a baker. So yeah, Joseph McKenna. Now let's go ahead and look at his Wikipedia article. Yeah, served in all three branches of the U.S. federal government. Was on the U.S. Supreme Court, Judicial Branch, U.S. House of Representatives, the Legislative Branch, and served as Attorney General, which is part of the Executive Branch. So he served in all aspects of government. He served on the Supreme Court for the time of, let's see, one of 17 members who was in the House of Representatives that served on the Supreme Court. So yeah. District Attorney for Solano County in California. Won a seat in the California State Assembly. Retiring after one term in an unsuccessful bid to be Speaker. And then would go on to, after on his third attempt, to win a seat in the House of Representatives for the U.S., serving 4 total terms. He was a vehement proponent of Chinese exclusion, which we talked about the Chinese Exclusion Act, where they wouldn't give them citizenship. It's like, really? Even though they're born here? Appointed to the Ninth Circuit Court of Appeals in 1892 by President Harrison. 1897, he would become Attorney General for President William McKinley. Succeeded Stephen Johnson Field. Never developed a consistent legal philosophy. He was the author of a number of important decisions. Most notable was his opinion in the case of United States versus the U.S. Steel Corporation in 1920, which held that antitrust cases would be decided on the rule of reason principle. Only alleged monopolistic combinations that are unreasonable restraint on trade are illegal. So yeah, it is kind of saying, if it looks like it's probably going to be bad, it's a judgment call. Authored 614 majority opinions and 146 dissenting opinions while on the bench. had a passionate rebuttal to the denial of pecuniary benefit to a wife whose husband had been killed while working on the railroad, was among those who brought a change to the Employer Liability Act. Yeah, so basically the wife was denied by the railroad company that they owed her anything, and he's like, no, that's not right. Her husband worked for the railroad, and as his widow, she should be eligible for that, for benefit from him being working on the railroad. Also, notable opinion: Hippolyte Company versus the U.S. A unanimous court decision upheld the Pure Drug and Food Act of 1906, consumer protection law, that led to the creation of the Food and Drug Administration, and whose main purpose was to ban foreign and interstate traffic in order adulterated and mislabeled food. Upheld the Mann Act in the case Hope versus the United States. And, that was a sex trafficking law. Hope versus the United States held that the U.S. Congress could not regulate prostitution per se, which was strictly the province of the states. However, Congress could regulate interstate travel for purposes of coercing sex. Because, yeah, the trade in between states, Congress did have a bit of power on, since it was a more of a federal matter. But the court's decision 4 years later, he dissented in Caminetti versus the U.S., in which uh, dealt with Farley Drew Caminetti and the Mann Act, in that the court said the Mann Act applied not only to purposes of coercion and prostitution, but also for non-commercial consensual sexualizations. So not just prostitution, but just, hey, you wanted to get together and have sex. It was consented to. Everybody, it just wasn't commercial. There was no money exchanged for it. So, yeah. Number of cases: married Amanda Borman in 1869, and they had 3 daughters and 1 son. His elections, okay. But yeah, there's an image of Joseph McKenna. Like I said, appointed to the Supreme Court by William McKinley, McKinley's only nomination, because McKinley would be assassinated and replaced by his Vice President Theodore Roosevelt, Teddy Roosevelt. He would also serve as an Attorney General under McKinley. Appointed to the U.S. Court of Appeals by Benjamin Harrison. represented California's 3rd District in the U.S. House of Representatives. So, yeah. Now, let's go ahead and take a look at Oliver Wendell Holmes Jr. Joined on December the 8th, 1902, replacing Horace Gray. He was born on March the 8th, 1841, in Boston, Massachusetts. His father was a famous doctor and writer who exposed Holmes to the brilliant minds in the Boston area at an early age. I was wondering if he was related to Oliver Wendell Holmes. I've heard of a writer, Oliver Wendell Holmes. I guess it is, yeah, that he was his son, so yeah, okay. Holmes graduated from Harvard in 1861 as the Civil War was beginning and served the Union Army during the war and fought in several of the bloodiest battles. He was wounded in the chest, the neck, and the heel during his service. Left the Army in 1864 and enrolled at Harvard Law School, received his law degree 2 years later, and admitted to the Massachusetts bar in 1867. Spent the early stages of his career in private practice, lecturing at Harvard. In 1882, was appointed a professor of law at Harvard, but did not stay in that position long. At the end of the year, he joined the Supreme Judicial Court of Massachusetts and became Chief Justice of that court on August 1899, and would serve in that capacity for the next 3 years. On December the 2nd, 1902, President Theodore Roosevelt nominated him to the U.S. Supreme Court, and the Senate confirmed him on December 4th. He would take judicial office 4 days later, serve on the court for nearly 3 decades, just over 29 years, voicing his views confidently and succinctly on topics from taxes to pollution to music and baseball. In the aftermath of the First World War, he penned several opinions that shaped the evolution of the free speech doctrine, and writing for the court in Shank versus the U.S., he outlined a clear and present danger test for the boundaries of the First Amendment protection. Holmes noted that the most stringent protection of free speech should not protect a man from falsely shouting "fire" in a theater and causing a panic. In a dissent in Abrams versus the U.S., though, he observed that the best test of truth is the power of the thought to get itself accepted in the competition of the market. This theory of marketplace of ideas persists today as a justification for freedom of expression, although the court left behind the clear and present danger test in the late 1960s. He also dissented in Lochner versus New York, the most famous of several decisions in which the court relied on substantive due process to strike down economic regulations. He wrote that a constitution is not intended to embody a particular economic theory, and urged greater deference in legislatures in this area. The court would eventually embrace his view, and he is rightly admired for his contributions to many fields of law, but wrote one notable opinion that modern readers would not applaud. In Buck v. Bell, he upheld a Virginia law that provided for the compulsory sterilization of inmates of state institutions found to have hereditary insanity or imbecility. He bluntly summed up his view by proclaiming 3 generations of imbeciles are enough. He left the Supreme Court January 12, 1932 at the age of 90 and remains the oldest justice in Supreme Court history. Would be replaced by Benjamin Cardozo on the court, and Holmes would die March 6, 1935 in Washington, D.C., being buried in Arlington National Cemetery. So another interesting individual being buried at Arlington. And of course, like we said, he served during the Civil War, so yeah. Noticeable opinions by Holmes. U.S. versus Kirby Lumber, dealing with taxes. When a corporation purchased and retired some of its own bonds for less than their par value, which it had received for them, then when issued, the difference was a taxable gain or income. Okay. Lucas versus Earl, also dealing with taxes. The tax law can tax salaries to those who earn them and provide that the tax cannot be escaped by anticipatory arrangements and contracts, however skillfully devised, to prevent the salary, when paid, from vesting even for a second in the person who earned it. So it's saying, look, yeah, salaries can be taxed, and it doesn't matter how you try to word things. You can't avoid it. There was one way I know that did avoid it, because states that were commonwealths, Virginia, Pennsylvania, Kentucky, Massachusetts, if they were unaware of it, may have been dealing with state tax, but yeah, the taxes wouldn't have to be taken out if the person was unaware of them. It could have been federal, but yeah, I know it's one of them. I always thought that was interesting. But the Bell, dealing with due process. The state may provide for the sexual sterilization of inmates of institutions supported by the state who are found to be afflicted with a hereditary form of insanity or imbecility. Imbecility. Prestonets Incorporated versus Cody, dealing with trademarks. The ownership of a registered trademark consisting of a name designating the owner's goods generally does not carry with it the right to prohibit a purchaser who repacks and sells them with or without added ingredients from using the name on their own labels to show the true relation of the trademark product to the article that they offer. So yeah, if the purchaser repacks and sells them, they are allowed to use the name because that shows specifically what it was. Moore versus Dempsey, due process, criminal trials, and prosecutions. A trial for murder in a state court in which the accused were hurried to conviction under mob domination without regard to for their rights is without due process and thus void. Yeah, so a group of people couldn't force a conviction hurriedly. And it's like, look, this has got to be done fairly and honestly. The trials do. Because if you try to force a conviction, no, that's not permitted. Pennsylvania Coal Company versus Mahon, property rights and land use. If regulation goes too far, it will be recognized for taking as a taking for which compensation must be paid. I disagree. But again, we're looking at an era where a lot of labor laws were just starting to come into power, come into force. So yeah, I think regulations are there as stringent protections because we see what happens when you just let corporations do what the fuck they want. It always fucks shit up, causes the worst outcomes. Federal Baseball Club of Baltimore versus the National League of Professional Baseball Clubs. The business of providing baseball games for profit between clubs of professional baseball players is not within the scope of federal antitrust laws. Hmm. I guess because Baltimore felt they could play whoever they wanted to play, and the National League of Baseball Clubs said, no, you have a schedule you have to stick to. Missouri versus Holland, powers of Congress. Treaties made under the authority of the United States, along with the Constitution and laws of the United States made in pursuance thereof, are the supreme law of the land. So, yeah, Constitution and federally the United States um, are the supreme law. It's what must be followed. States cannot make laws that supersede it. Abrams versus U.S. Holmes in dissent on free speech. It is only the present danger of immediate evil or an intent to bring it about that warrants Congress in setting a limit to the expression of opinion when private rights are not concerned. So yeah, if it's something public, they can say whatever they want as long as it does not put people in clear and present danger. Debs versus the U.S. I'm sure this dealt with Eugene B. Debs. Dealing free speech. The delivery of a speech in such word and such circumstances that the probable effect will be to prevent recruiting, and with that intent is not protected because of the fact that the purpose to oppose the war and obstruct recruiting and the expressions used in that regard were not incidental parts of a general propaganda of socialism and expressions of the general and conscientious belief. Yeah, because Eugene B. Debs, socialist, one of the biggest names in socialists. In fact, he ran for president and got several, I think it was a couple million votes, actually doing pretty well. And he was running while he was still in jail at that point. I think he was out at this point, but yeah. Um, So basically, whatever he said, probably a protest on the First World War and trying to push back on the recruiting and everything. They said, no, what you're doing is obstructing it and it's not protected. So, yeah. Um, Pro work versus the U.S. dealing with free speech. The First Amendment, while prohibiting legislation against free speech as such, was not intended to give immunity to every possible use of the language, saying there are some things you cannot just go around saying, notably, like he said, with the clear and present danger test. Shank versus the U.S. Free speech. Words that ordinarily and in many places would be within the freedom of speech protected by the First Amendment may become subject to prohibition when of such a nature and used in such circumstances as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. Again, there are certain things. The freedom of speech provides you a lot of leeway, but there are certain things, if it provides a clear and present danger, and the um, yelling fire in a theater has always been kind of the example. So, yeah. Herbert versus Shanley Company dealing with copyrights. The performance of a copyrighted musical composition is in a restaurant or hotel without charge for admission to hear it, but is an incident of other entertainment for which the public pays infringes the public performance right. So, they have a right, if there is a public piano in a hotel or restaurant, yeah, as long as they're not charging for it, they have a right to play whatever. Bimetallic Investment Company versus State Board of Equalization of Colorado dealing with government agencies. When a rule of conduct applies to more than a few people, it is impracticable that everyone should have direct voice in its adoption. Thus, an order of the State Board of Equalization increasing the valuation of taxable property in a city did not violate due process just because no opportunity was given to the taxpayers of the city to be heard before the order was made. So yeah, you should have the right to um, voice against certain things if it deals with multiple people. But if it's basic rules, taxation and stuff, yeah, nothing you can do about it. It don't violate due process or anything. Um, Bugajewicz versus Adams, immigration and national security. Deportation is not a punishment, but instead a refusal by the government to harbor persons whom it does not want. The constitutional prohibition on ex post facto laws has no application to deportation. So, yeah, you cannot arrest someone, go back and make a law so you can kick them out. Basically, you can't go back and make laws just so you can arrest people and backdate them. No, the point of the law only takes effect after it's been made a law. There's no backdating the way they're made or enforced. Georgia versus Tennessee Copper Company, climate change and environment. In its capacity of quasi-sovereign, the state has an interest in all the earth and air within its domain, independent of the titles of its citizens. It is fair and reasonable for a state to demand that the air of it over its territory should not be polluted on a great scale, and that its forests, crops, and orchards should not be destroyed or threatened by acts of parties beyond its control. Yeah, dealing with climate change and environment. So I'd say Georgia was suing the company, Tennessee Copper Company, because apparently the methods they were using to try to extract whatever minerals were causing a lot of poisons, uh, whether it be through runoffs or smoke, soot, all kinds of stuff. So yeah, and it's basically saying no, they have a right to sue because what you are doing is actually affecting the state. Missouri versus Illinois. The role of courts, climate change, and environment. The Supreme Court should only intervene to enjoin the action of one state at the command of another state when the case is of serious magnitude, clearly and fully proved. Only such principles could be applied to the court as prepared to maintain. This dealt with sewage polluted water, but basically it's saying, look, normally cases between states are dealt in state courts, but when they are of a serious enough matter, the Supreme Court can step in and decide things. Um, and Swift and Company versus the U.S. dealing with antitrust. Even if the separate elements of a scheme are lawful, when they are bound together by a common intent as parts of an unlawful scheme to monopolize interstate commerce, the plan may make the parts unlawful. So even though uh, parts um, of what you're doing are fair, are lawful, if it involves interstate commerce, trying to do something in one state to make money in another state, uh, yeah, it can be unlawful because that comes under the focus of the federal government. And finally, Blystein versus Donaldson Lithographing Company. The least pretentious picture has more originality in it than directories which may be copyrighted. I'm not sure on that one, but yeah. I guess dealing with copies and stuff because yeah, the least pretentious picture has more originality. So I'm assuming talking about it or your copies of it or whatever. But yeah, let's jump over to Oliver Wendell Holmes. Comes from an illustrious family, and his contributions throughout life and distinction to an otherwise distinguished group. Uh, was a class poet in 1861 while at Harvard, and was commissioned a second lieutenant in the Massachusetts 20th Volunteers for the Civil War. Wounded 3 times in the war and carried one of those bullets in his body until his death at the age of 93. Left military service as a captain, returned to Harvard to go to law school. After law school, he entered private practice, but soon returned to teach constitutional law, lecture, and write, and at the age of 40 published his treatise, The Common Law. He found academic life incomplete, though, and accepted appointment to the Massachusetts Supreme Court and served for 20 years. Teddy Roosevelt thought Holmes's views compatible with his own, so he nominated him in 1902 for a position in the Supreme Court, and the Senate confirmed his appointment without objection 2 days later. Key player in 4 major courts: Fuller, White, Taft, and Hughes. In 25 of his 29 years, he never missed a session of the court and walked from his home to the court daily, a distance of 2.5 miles. By endurance alone, he qualifies as the Cal Ripken Jr. of the nation's highest bench. By temperament, he asserted pragmatic views of the law and balanced his deep skepticism in human nature against the stabilizing rule of law, yet treasured liberty in the same spirit as the playwright Robert Bode envisioned in Sir Thomas More, who was executed in 1535. More, like Holmes, put his trust in the law. His opinions will endure largely because he kept them short and studied many with vivid phrases. This left little work for his law clerks. One of them, Alger Hiss, spoke about his responsibilities when he worked for Holmes in 1929. Near the end of his long career, he reflected on life and work and the final moments which he knew were soon approaching. Was English, Unitarian religion, from an upper-class wealthy family, mother Amelia Lee Jackson, and father Oliver Wendell Holmes, who was a professor, poet, and physician. Now let's go over Wikipedia to see if there's anything else of note. Served in the Union during the Civil War as a brevet colonel. Appointed by Teddy Roosevelt. Yeah, the memorable idea that free speech would not protect a man in falsely shouting fire in a theater and causing a panic, thus making the clear and present danger test. Identified by the University of Chicago Law Review as the 6th most cited American legal scholar of all time. So yeah, clearly plays an important role in legal history, judicial history. Jurisprudence and academic writing influenced much subsequent American legal thinking, including the judicial consensus upholding New Deal regulatory law, sociological jurisprudence in the early 20th century, and much of legal realism a generation later. Let's see. Apparently, his ancestors were from England during the early colonial period as part of the Puritan migration to New England. Um, they were connected to leading families. Henry James Sr., Ralph Waldo Emerson, and other transcendentalists were family friends. While still in Harvard College, he wrote essays on philosophic themes and asked Ralph Waldo Emerson to read his attack on Plato's idealist philosophy. And Emerson would reply, "If you strike a king, you must kill him." So it's like, while your ideas are good, I don't think they're damning enough if you're going to really go after someone like Plato. Served in the 4th Battalion of the Infantry in the Massachusetts Militia, 2nd Lieutenant, while in the 20th Regiment of Massachusetts Volunteer Infantry, was at the Battle of the Wilderness, Antietam, Chancellorsville, some big name battles. Um, rose to the rank of Lieutenant Colonel, but eschewed command of his regiment upon his promotion. Uh, do, do, do. Holmes is said to have shouted to Abraham Lincoln to take cover during the Battle of Fort Stevens, though this is commonly regarded as apocryphal. So yeah, it's like it's something Holmes himself claims. Nothing we have real proof of. Lawyer, teaching at Harvard Law School, writing the common law treatise, time as a state court judge, Supreme Court judge, opinions on the Supreme Court. We went over enough as is. Jurisprudential contributions, the critique of formalism, legal positivism, his speeches, letters, retirement, death, honors, and legacy. honored on his 90th birthday on one of the first coast-to-coast radio broadcasts, during which Chief Justice Charles Evans Hughes, Dean of Yale Law School Charles Edward Clark, and the President of the American Bar Association read Encomia. So yeah, widely regarded by uh, the fellows of his time. So yeah. Many secretaries formed close friendships with one another, wrote Tony Hiss, son of Alger Hiss, about the special club of clerks of Oliver Wendell Holmes Jr., including Robert M. Benjamin, uh, a later lawyer for an appeal by Alger Hiss, Thomas Corcoran, Lawrence Curtis, a U.S. representative, Hiss himself, president of the Carnegie Endowment for International Peace, and a convicted perjurer, Donald Hiss, partner of Covington and Burling law firm, Irving Sands Odes, chairman of U.S. Steel, H. Chapman Rose, Undersecretary of the U.S. Treasury, and Chauncey Belknap IV, named partner in Patterson, Belknap, Webb, and Tyler, one of the largest law firms in New York during his time, and an attorney for the Rockefeller Foundation, was also father of Robert L. Belknap, and how seen in popular culture. But yeah, Oliver Wendell Holmes Jr. But with that, we'll go ahead and end this episode here. It's already been a long one, almost an hour. But as always, educate thyself. Think, read, study, learn. Someone tells you something you have trouble believing, ask them to cite their sources. It can't be a bunch of tinfoil hat wearing sources or anecdotes slapped together to make sources. I'll be putting my links and sources in the description box below the video. Thank you all for watching. I'll see you all in the next one. Until then, later.